I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call this morning's docket.
Thank you, Your Honor. May it please the court. The 10 a.m. docket for Tuesday, April 29th, 2025 consists of one case, appeal number 127534, State of Kansas versus Stanton, Holt, Geary County. Briefs both sides. Counsel will enter their appearance.
Kristen Patty, counsel for the appellant Stanton Holt, present and ready for argument.
Your Honors, and may it please the court, Andrew Lohman, Assistant Solicitor General, on behalf of the state, present and ready for oral argument.
Your Honor, the appellant has requested 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Ms. Patty, you may proceed.
A little over 30 years ago, there were a string of burglaries in Junction City, mostly between March and the end of April. During a couple of these burglaries, 2 people lost their lives. My client, Stanton Holt, was convicted of 2 counts of first-degree murder, 2 counts of aggravated robbery, and about 50 or 60 other counts. The timing of this is important because in April 1993, we had a different sentencing scheme than we do now. So the sentencing guidelines went into effect effective July 1st, 1993. He was sentenced under what we call the indeterminate sentencing. So he is serving 2 consecutive life terms plus 123 to 355 years in prison. And I don't remember exactly his age. He's now sometime around mid-60s, I think. This is not the first time that he's been before the court. I think he's had 9 appeals total. This makes his 10th, and it's also not the first time that I've represented him. He continues to maintain his innocence, and a few years ago, after his last appeal, he requested DNA testing. What's interesting about this is it took him a while to find the evidence from his trial. They did. It had all just been like thrown back into a banker's box in, I guess, like Dylan's grocery bags, and it ended up in some, not even in a secure court storage room, but in some storage shed off-site. And it took the prosecutor and the attorney appointed to represent him in district court a little while to find that. The district court ordered DNA testing in this case. And as you know, under 21-2512, which is the DNA testing statute, we then have a process that we go through. As part of this process, though, because of the quality of the evidence and how it was found, the district court determined that the evidence, if tested, would not be reliable, that the results would not be accurate, and for that reason he denied Mr. Holt's motion. The problem is that's not what the statute sets out as far as the procedure. We have a procedure that we go through. We have the testing, and then we determine whether the results are favorable, unfavorable, or inconclusive to the movement, the defendant in this case. I suppose the question for this court is, did the district court put the cart before the horse? Did it, in essence, go through and determine For example, whether if the results have been inconclusive as a basis to deny the motion without actually having the evidence tested.
If I could, please. Referring to the statutory language, it says that the court shall order DNA testing, and this is subsection C. Kansas statutes annotated 21-2512, subsection C. The court shall order DNA testing under A upon a determination that the testing may produce non-cumulative exculpatory evidence. And here, the state is arguing that Holt would not be entitled to any relief because the results would be inconclusive or incriminating. And it reminds me of a story that one of our law clerks, and for the audience, a law clerk is a lawyer who went to law school, has passed the bar exam, and works at the elbow of a judge or a justice with research and writing, etc. I'm reminded of Howard Mahan, who is one of our law clerks, of a story. He worked at a rural 9-hole golf course during high school, and there were a lot of volunteers who helped, and one time a helpful individual decided to apply a moth-killing dye to one of the ponds, and the chemical killed all the fish overnight. You could tell because the fish were floating the next morning and they smelled, well, like a bunch of dead fish. Allowing DNA testing in this case would be like fishing in that pond of dead fish. Maybe fishing is possible, but it's certain nothing of value could be caught. Would you agree with that?
Well, I guess the problem is, Your Honor, I think that in other cases, this court has said that 21-2512 permits a fishing expedition. We try to see just if there's anything that might help the
Even if all the fish are dead?
Even if all the fish are dead. I suppose that the legislature, in its wisdom, wanted to say, if all the fish are dead, it could have put it in there, obviously not exactly
Counsel,
in that term.
isn't that effectively what the legislature did say in subsection C, which Justice Standridge referenced, requiring a showing of potential exculpatory evidence? Isn't that the hurdle that your client struggled and ultimately failed to get over?
I suppose that we can't really tell, and I guess we're really using analogies today, we can't really tell whether it would produce potential non-exculpatory or non-cumulative exculpatory evidence until we test it.
Well, but that's a factual question, and the district court heard testimony from KBI experts and issued a ruling based squarely on that testimony. Would you agree with that?
I would agree with that.
So did the district court, was the finding not supported by substantial competent evidence?
Based on the testimony and really the stipulation, I suppose, of the attorney who represented Mr. Holt in district court, I think the transcript shows that both the county attorney and the attorney appointed to represent Mr. Holt advised the court on the record the condition that they found the evidence.
But more important is the testimony rather than the statements of the attorneys, right? I'm just trying to figure out whether or not you are arguing that the evidence that the district court heard did not support its factual finding that there was no chance this testing could generate exculpatory evidence. That's the nut of the district court's ruling.
And I think the phrase here is no chance. I think.
But was the evidence that was in front of the district court sufficient to support that finding or not?
To the extent that the KBI testing expert could actually remember, she was, I think she uses phrases like, well, I think I remember going down to where this evidence came in. And she didn't remember specifically, it sounds like, from her testimony. It had been a little while between the time that the evidence was transmitted to the KBI and then when they had the hearing.
I'm sorry, if
No,
you're not
save me.
finish your question. The state seemed to argue that the reason it could not help was that the analyst would not be able to identify within a reasonable degree of scientific certainty. That's my old trial court days coming back. Anyways, but do we know that? Or is that even the point? Is the fact that we couldn't identify whose DNA was there that important, or is it more that Mr. Holt's DNA was not there? And did she testify that she could not testify about that to?
I think that it would be important if, once we know the results. Without the results, and again, this is kind of a cart before the horse type12 how can we judge materiality, which is what we would have to do under, say, 212512 F2. How can we judge materiality until we know what those results are?
But did you finish your answer? I'm sorry.
Go ahead.
But wasn't that the point of the district court's ruling, is that testing essentially would be futile because the testimony of the KBI DNA expert indicated that it would not generate reliable results. So if you actually went forward with testing, I'm wondering, how does that even come into evidence? I mean, you would need expert testimony, and you don't just admit any evidence under our evidentiary rules. The cornerstone of that rule is scientific reliability. So if this DNA test results would be inadmissible and unreliable, how could it stand or support any conclusion?
I think the best way to answer that is in other circumstances, say in a trial court proceeding, and I can't quite think of an example off my head, but sometimes there is a fight before a case goes to trial about whether a particular part of evidence should come into, say, be presented to the jury. And the ruling is, well, that's for the weight and credit for the jury to determine, right? And it would seem like that's the same sort of thing here. And again, back to the materiality argument, how can we determine what weight and credit to give this evidence, these test results, before we know what those results are?
And the answer to that is because we know the condition of the items that are about to be tested. And all of the evidence says the condition of this evidence is such that there's no possible result that the testing could reach any kind of conclusion about it being exculpatory. The facts that you need are on the front end, which is what's the condition of the stuff that was packed away in this Dylan's grocery sack, as you described it, for all those years, because everything gets mushed up in there. And so that's, to me, the factual focus. So how do you get any result out of here that can possibly help you when the condition of the evidence cannot give you a test result that works for you?
In another DNA testing case, Hernandez, said that, at least as far as whether to consider ordering testing, that exculpatory by the smallest margin is sufficient. So again, back to like with Justice Siegel.
What's
you know,
the evidence that there's any margin for you? That's your problem here, because it's the evidence that the district court heard and found seems to have closed every possible door you've got. And that's why the district court ruled the way it did.
And I guess my job is to convince you that it's not absolutely zero.
And what evidence is there of that? What testimony, what presentation was given to the district court that would counter that conclusion?
Again, I mean, I am sorry if I'm repeating myself, but really, until we know what the results are, how can we judge the materiality?
And again, I get back to, but we know what condition the stuff is that has to be tested, and given that condition, you can't get a test result that helps you. So all we have to know are the facts of what's in the sack, and whether you can prove that only Mr. Holt's DNA was present in 1993, as opposed to some other time. You just can't get there.
It would appear to be slim, but again, the smallest margin would appear to be sufficient. I don't know that we can really truly say that it's zero until we know what those test results are.
Before you sit down, Ms. Patty, can I point you to the state's second issue that was brought up on appeal and apparently was not before the district court? And that is that the items that your client requests to be tested for DNA was in fact tested at an independent lab prior to the original trial, utilizing the same means that the KBI utilizes now. So there's not like an advancement in the technique that's utilized by DNA specialists. What about that? Everything that he wants tested was tested for DNA. And do we just ignore that? I mean, I'm surprised when I look back that wasn't brought up at the evidentiary hearing. I don't understand why, but if that's true, doesn't that just do away with all of this?
Well, and I will tell you that, I was a little surprised too when I read the state's brief, because no, it hadn't been argued by anybody before. The record for this appeal, it exceeds 4,600 pages. And so I think in some ways everybody could be forgiven for not recognizing this before my colleague did. The other part that I wish were...
Well, tell us why we shouldn't consider that. I mean, I guess, procedurally we would have to make an exception, but why shouldn't we make an exception when it seems pretty clear that's what occurred?
I guess two things. Number one, the DNA testing expert, there was not a lot of elaboration, but that the techniques had improved, even if it was the same technique, since 1993. And I guess probably the most apt analogy is think about what kind of televisions we had in 1993. And we had standard definition. And my gosh, if we look back to what we consider to be a great TV picture then, it's like, looking through fog now, right? So I did a little Google research. I think that maybe they are able to determine DNA and extract profiles from much smaller quantities than they are now, but that is not in the record. Certainly, I wish that the attorney who represented Mr. Holt in district court had gotten more testimony, better testimony on that part. The other thing is a decision from this court 3 years ago, Angelo, in that case, and procedurally, it was different because we didn't have an evidentiary hearing. Instead, there was looking for my notes. The prosecution, it was summary dismissal, which means the defendant filed a motion, the state filed a response, the judge ruled, there was no hearing in court, no attorney for the pro se defendant. And one of the things that was instrumental to this court's decision was that the prosecution failed to disclose to the district court a factual dispute regarding the existence of biological material. And similarly here, the prosecutor never filed a response to Mr. Holt's motion. She did not alert the district court to the fact that there was a factual dispute about this testing and whether it had been done previously, so that then the district court could delve further into the changes in technology that have occurred over the last 3 decades.
I want to make sure my memory's good on this point. After the state raised this issue about the prior trial and that this evidence had already, this DNA testing had already occurred, I don't recall that you replied to that argument. Am I right?
I did not. I got swamped over the last few months of last year and the beginning of this, and so I did not respond. And maybe I should have. Like I said, it was not something that was alerted to the district court at all.
It sounds to me like you're basically saying if we agree with you on issue 1, the best the state can do is try to argue their issue 2 on remand, where the district court would have to hear new evidence about the testing techniques and so on.
Possibly.
Okay.
Yes. And I see that I'm horribly out of time. If there are no further questions, I'll come back and rebuttal.
Thank you. Mr. Lohman?
Your Honor, may it please the court, and just for some background information, the statute allows testing of biological material. In this case, Mr. Holt is seeking testing of gloves, tire iron, shoes, and jeans that contain blood on them, and then swabs of those items. At the original case, the KBI received these 4 items. They had I think it's RFLP testing techniques, which does not do well with trace testing. So they did submit it to California, which uses polymers polymers chain react testing, which is better with trace testing. At the evidentiary hearing, the KBI lab tech testified about that. They currently use the PCR testing methods. To qualify for post-conviction testing, the biological material must either have never been tested by DNA testing, or can be subjected to new DNA testing techniques that provide a reasonable likelihood of more accurate probative results.
I would like to,
Yes.
I
Go
just
ahead.
briefly would like to ask a question about that. You're raising this issue, and one of the things you're saying is that it's a newly asserted theory that involves only a question of law on proved or admitted facts. But isn't this really, as I think Justice Stiegel just said, not a question of law, but really whether or not new DNA testing would has advanced since then, and we would not only have to look at what the KBI does now, but we'd also have to have someone come in and testify to exactly what the difference between the two would be. It would be an evidentiary issue, correct?
Ultimately, if he wanted to submit it to another facility, as far as the KBI, I would argue that changes within the technique would just be changes in the technology within PCR testing.
Right, but you're saying you would argue, you as a lawyer would argue, but isn't it an evidentiary issue? Wouldn't you have to prove that to a finder of fact?
I believe if he wanted to submit it for testing other than PCR testing.
Right, but I'm talking about raising the issue now before us. We can't make any finding on this, right? We would have to make a factual finding.
I would argue it's finding a law that the PCR testing is within the same technique.
And upon what, where is the law? Is it a statute? Is it case law? Is it?
It'd be an interpretation of the term technique. And why I don't believe technique should be read so broadly as to any change within PCR testing.
Well, at a minimum, I think you would agree that your expert, the state's expert, the KBI testing expert, was not subject to cross-examination by the defendant's counsel on this question of whether it was a new technique, because the issue was not before the court. Would you agree with that? And so at a very minimum, it seems there remains at least a procedural opportunity for further factual inquiry.
I would agree that further factual inquiry would be beneficial to.
So are you essentially agreeing that if we rule against the state on issue one, the best the state can hope for is to raise this prior testing on remand?
If the court indeed finds that it is a factual question, just PCR testing in itself is not, is within the same technique.
Thank you.
Then I would have to concede that. And then, but even if the court finds that the technique is different, there still must provide a reasonable likelihood of more accurate and probative results. In this case, the KBI expert testified that that's not the case. We're not going to get accurate results, certainly not more accurate results than just properly preserved evidence that was submitted to what appears to be the best technology at the time, the PCR testing in California.
Counsel, can I ask you a question about that? Your argument is that essentially, given the way that these items were stored and are maintained over the course of time, it essentially renders DNA testing unreliable at this juncture. But I guess my question is, what obligation does the state have to maintain this evidence post-conviction in a condition that allows for a defendant to pursue the remedy that the legislature has created under this DNA testing statute?
To my knowledge, there isn't a standard, and I believe that would be something that should be addressed in possibly the legislature.
It's not in the statute.
That's correct.
Is that the state's position, I would assume?
Yes.
And so is there a due process, any sort of obligation to your knowledge? Or?
Not to my knowledge. Unfortunately, I think this was just an unfortunate circumstance in this case.
Then what is the incentive for the state to maintain evidence in a manner that the statute can be complied with? I just don't see any. So what's your position on that? How do we deal with that when, I appreciate this was 30 years ago, before the enactment of the statute, but even with a current case, even with those cases, is there an obligation of the state to keep evidence in a manner in which it can be tested or re-examined?
I don't believe so.
There isn't. So there's no incentive for the people you represent to do anything. They could throw it away. Well, that's what you're saying.
Unfortunately, I don't think anything would prevent that. There could be standards out there within record keeping within law enforcement agencies.
Well, doesn't the statute that we're talking about itself touch on this? Subsection B2 does impose a requirement on the state to take such steps as are necessary to ensure biological material is preserved. But that obligation only kicks in upon the filing of the motion, correct?
That's correct.
And doesn't that, I realize it might be a stretch, but there's at least an inference that there is no duty prior to, at least no statutory duty prior to the filing of the motion.
I believe so. That there would be, there's no statutory, like, as Justice mentioned, that this statute, I believe, was enacted in 2001. The case was 93 or 94, it might have been tried, but unfortunately, yeah, this is a case of unfortunate circumstances. And then I don't believe the state wants to get the right person also, so there's that there too, but.
Would a defendant have a legitimate due process claim?
I don't believe so. The argument would make more sense now, after the statute's been enacted, that now we do have post-conviction testing available to defendants, but at the time when this was thrown in, I just don't know what they could foresee at the time. So I don't think there would be a due process issue, at least for Mr. Holt, maybe now, but.
Well, does the intent of the state or have anything to do with the due process claim?
Possibly, if you could deduce that it was to sabotage the case, but I don't think that's going to be the case here.
It might not be the case, but how does that get before the court to determine that? What if there's just bad faith? There might be something here, I want to destroy it. It's kind of a point I made in a concurring opinion 6 months ago involving lost evidence. What about bad faith? So you're saying that there's really no remedy, even if there is bad faith on the part of the law.
But there's bad faith, I imagine it'd be a 1507 action of some sort, or some sort, not a post-conviction, not this sort of proceeding. And then, yeah, just in addition to the fact that it is not more likely to do accurate probative results, also similarly, it would not produce any sort of exculpatory evidence. Really, the evidence in this case came in two categories: the tire iron, the gloves, and the shoes Mr. Holt denied that he was the owner of. The jeans he admitted he was the owner of. There was blood stain in the back, which was the result of him being shot. And then there's blood stains on the front of on the knees. Mr. Holt asserted that that was his own blood. The state's argument is that it was a victim's blood. Ultimately, only the shoes could be tested consistent with the victim's blood. On retesting, Mr. Holt argues that if the DNA evidence tested positive for his blood, then that would be exculpatory. It only works with the jeans, because he argued that the other three objects he was not in possession of. And then if the evidence was in testable quality, the argument could be made that, yes, if the front of the pants tested solely for his blood, that would be exculpatory, just the minimum, but with the evidence in the state as it is, it won't mean anything. Ultimately, he was the wearer of the jeans. As the KBI agent mentioned, the moisture from the bags would degrade it, so any sort of evidence from the victim would be gone.
Why would, somewhere in there you said that his not having any DNA, his DNA being on the gloves or the tire iron would not be exculpatory? Why would it not be? Wouldn't that verify his claim that he did not possess those?
If it was not on there?
Yeah, if it was not on there. I mean, it might not prove it,
Sure.
but it would at least be circumstantial evidence validating his testimony or his statement.
Well, the testings of the biological material, in the state's theory was that the blood belonged to the victims of those.
Right.
But that evidence was presented at trial, right?
What's that? Sorry.
That was presented at the original trial.
That is correct, yes.
That there was no, his DNA was not on the tire iron or, what was the other thing?
Tire iron, gloves.
And the gloves,
Yes.
but that it was, but was his DNA, that they proved that, or they said that they were his shoes, they were found in his closet, they were his size, they were, and that the victim's blood were on there. That was all in the original trial, right?
That's correct. Yeah, the gloves and the tire iron.
So that
didn't
wouldn't
come
be
back
new
with anything.
evidence, because if his DNA was not on the tire iron or the gloves, that's not new evidence, because it wasn't on there 30 years ago.
That's correct.
Well, wasn't it that they didn't have enough material to test on the tire iron and the
Maybe I'm
gloves?
wrong.
They could not detect?
They
Testable material?
attempted to, I forget if the KBI tried to, the KBI tried on some things, but wasn't able to do it. California couldn't come up with any sort of typing results.
And one of the fact questions we might have on a remand would be, under current techniques, was it enough, would there be enough there that they could now do DNA testing that they couldn't do 30 years ago?
Yeah, my biggest issue with at least those three items would be if his DNA is present, then that goes against his theory. If it's not present, then that goes towards the state's theory that the blood belonged to the victim, not Mr. Holt.
Based on this evidentiary record, my reading of it at least, is that all this discussion about what the tests could show, whose blood was where, et cetera, is really a red herring, because as I read the KBI experts' testimony, they say, look, sure, we can test this stuff, but I'm here to tell you, no matter what happens, those test results will be unreliable. And isn't that what the district court based its ruling on?
That's correct.
Is it doesn't matter what the quote-unquote results are. If the expert, the only evidence in front of the court was they will be unreliable. Am I right that that's essentially the ruling that happened below?
That's correct. And the big thing would be with the genes, as much as like all the evidence, but the determination that it's not scientifically accurate to test this, it wouldn't result in any scientific accurate result, as a factual finding that was supported by substantial competent evidence. If there's no further questions, I'll.
Okay, thank you, Mr. Lohman. Ms. Patty, you reserve 3 minutes.
Obviously, I'd like to argue to you that, yes, the state violated Mr. Holt's right to due process by not preserving this evidence. But A, that wasn't argued to the district court. And for the audience, things usually have to be argued before the district court before we can argue them here. And then also because the DNA testing statute didn't go into effect until 2001, I'm not sure in 1993 whether there was the foresight of preserving the evidence the way we do it today. If you did, however, decide to vacate, for example, the murder of MP and the related charges, obviously Mr. Holt would request that. We didn't touch on, you have still pending a petition for review, State v. George, that was filed in late July. And at least all of my petitions for review from that time period and before, you ruled on about a month ago. In that case, the Court of Appeals basically said, and my colleague cited it in his brief, that a specimen is subjected to DNA testing if it is examined by a technician and determined to be an unviable candidate for further analysis. And I guess I think that potentially leaves it to the whim of somebody to say oh, I don't want to test this for some reason. And I don't know that that's really what the statute contemplates as far as testing.
I don't
And
understand that argument. I don't understand that argument, that it leaves it to someone's whim. I mean, if the state produces a bunch of people that say this stuff can't be tested, you're right there to be able to bring in somebody that says, just give it to me, I'll test it. And then the judge can decide who's telling the truth. But so I don't see how it leaves it to the whim. You've got the opportunity to challenge the expert that says this stuff is just a big bag of mess that we can't get any reliable results from.
And I did pull the petition for review for George, and it has been raised in that, that the statute contemplates when extraction is actually attempted and not when items are eliminated by a technician due to prospective inadequacies of the testing procedure. I think that's really fairly close to what we have here. We basically got the testing procedure is going to be inadequate, so why should we test? If there are no further questions, I'll stand on my brief. Thank you.
All right, thank you. Thank you to both counsel for your arguments today. The court will now take this appeal under advisement.